Dr. Besigye.
Sophia Abubakar Sekanjako Waswa also Kapuru Musime and Irene Nabunya. We are not advised as to why Dr. Besigye is not in court. Notwithstanding that this honorable document and court that in any event, if nothing has changed, it should be produced. That order being made by this honorable court. So remember that is defiance on the part of the prisons authorities.
So I've equally not received any communication from prisons as to why he's not here. However, the matter is coming for ruling today, and I am ready to deliver the same. If you're okay with that, or if you wish your client to be present, you can always give another date for the ruling.
Your Worship, we are ready to receive the ruling, but the prayer is that, first of all, the prisons authorities be remanded for defying the court order. Because that's a matter of contempt of court, Your Worship. We should have court unchallenged. So, we shall be breeding a culture of impunity in this country. Your Worship, if the prisons authorities are allowed to defy court orders with reckless abandon. What she just said here, going to ask, is Dr. Besigye around? Said no. She owed a duty to explain in what why. Not to just say, no, he's not here.
I understand why she doesn't know. I think she's from the female remand side. I wouldn't think she would know what's happening on the upper side of the remand. So we needed the right officers of Zira Upper. And I don't see any of them here. But we will take it upon ourselves to find out. I'll make the efforts to find out what exactly transpired.
Most obliged, we are nonetheless for us we are ready to receive the document.
So do you have anyone here from Luzira Upper Prison? No, any of the officers? This is the ruling of court. This is a ruling resulting from an application brought under Section 5 of the Human Rights Enforcement Act, Cap 12, on the enforcement of rights and freedoms by magistrates' courts among the prior sought, that the court exercises its jurisdiction to stay proceedings in criminal case number 624 of 2022, orders for cessation and continued unlawful detention of A1, Dr. Colonel Besigye, order authorities to seize the unlawful detention of A1, Dr. Besigye. The law relied upon is the Constitution, 1995 Republic of Uganda, the Human Rights Enforcement Act, 2019, the Judicature, Fundamental and Other Human Rights and Freedoms Enforcement Procedure Rules, instrument number 21 of 2019. As per Article 50 of the Constitution, provides that any person who claims that a fundamental or other right of freedom guaranteed under this Constitution has been infringed or threatened is entitled to apply to a competent court for redress, which may include compensation. Clause 2, any person or organization may bring an action against the violation of another person's or group's human rights. Any person aggrieved by any decision of the court may appeal to the appropriate court. Parliament shall make laws for enforcement of the rights and freedoms under this chapter. Refer to the case of Bukenya Church Ambrose versus Attorney General, which is a constitutional appeal number 3 of 2011 on the legality of Article 51 and 54 of the Constitution. Jurisdiction. Human rights can be enforced by the High Court or a magistrate's court, which under the Human Rights Enforcement Act of 2019 are referred to as the competent courts. Section 4 of that act is to the effect that the High Court shall hear and determine any application relating to the enforcement or violation of a non-derogable rights and freedoms guaranteed in Article 44 of the Constitution, b, other rights, duties, declarations, and guarantees relating to fundamental and other human rights and freedoms envisaged in Article 45 of the Constitution. Rights and freedoms restricted under a law made for purposes of a state of emergency, and d, rights and freedoms preserved by this act to be determined by a magistrate's court, where the remedy sought by the applicant is beyond the pecuniary jurisdiction of that court. Under subsection 2, applications under this subsection 1 shall be in the form prescribed by regulation and may, unless the High Court determine otherwise, be heard in open court. On the other hand, section 5 of that same act states that a magistrate's court shall hear and determine applications relating to enforcement or violation of human rights and freedoms guaranteed in Chapter 4 of the Constitution in any of the circumstances not referred to in subsection 1 of section 4. Under section 6 of the Human Rights Enforcement Act, a suit for the enforcement of human rights should be, where possible, lodged and instituted in the court in whose jurisdiction the alleged violation took place. Human rights matters can also be referred to the High Court, where they arise in proceedings in a magistrate's court, as referred to in section 7. They could also arise in proceedings in the High Court, in which case the court may stay proceedings and determine the human rights enforcement matters as per section 8. Refer to the case of Mangafu and 12 others versus Aglis Ranch, 20 and 21 Limited, and 3 others. It's a miscellaneous cause number 11 of 2020 for human rights actions of a public interest nature that have to be filed in the Constitutional Court. Accordingly, in the case of Magnafu, a case in public interest has to be instituted in the Constitutional Court. Locus standi. It's important to note that the right to apply locus standards is not only restricted to the person whose rights have been infringed or threatened, but can be brought by any other person. See Article 50, Clause 2 of the Constitution. Section 2 of the Human Rights Enforcement Act 2019 defines victim of human rights violation to mean a person who suffers a human rights violation and includes the person's immediate family or dependents or any other person whose rights have been violated as a result of the violation of the victim's rights and freedoms. Section 3 of that act states that in accordance with Article 50 of the Constitution, a person or organization who claims that a fundamental or other right or freedom guaranteed under the Constitution has been infringed or threatened may, without prejudice to any other action with respect to the same matter that is lawfully available, apply for redress to a competent court in accordance with this act. Under Rule 6 of the Judicature, Fundamental and Other Human Rights and Freedoms Enforcement Procedure, Rules, Instrument number 21 of 2019, the persons who may bring an action to court for redress are a person acting in his or her own interest, a person acting in the interest of another person, a person acting as a member of or in the interest of a group of or class of persons, a person acting in the public interest, or an association or organization acting in the interest of its members. As per that instrument, an action for enforcement of fundamental and other human rights and freedoms can be brought against any person, government, organization, Under Section 10 of the Act, public officers may be individually held liable for human rights breaches. This means that a particular public officer could be made a co-respondent to the action. That act also goes ahead to explain the procedure, and among the remedies in that act or reliefs, under Section 9 of the Human Rights Enforcement Act, court is empowered to issue appropriate orders, including compensation. Under subsection 2, the competent court may, in addition to the orders referred to, under subsection 1, order 4, restitution of the victim to the original situation before the violation of his or her human rights and freedoms, rehabilitation of the victim, including provision of medical and psychological care, or satisfaction, which shall include measures aimed at the cessation of the continuing violation of human rights and freedoms, verification of facts, full and public disclosure of the truth to the extent that such disclosure does not cause further harm or threaten the safety and interests of the victim's relatives, witnesses, or persons who have intervened to assist the victim or prevent the occurrence of further violations. 3. Restitution, compensation, rehabilitation, or any payment ordered by the competent court under this section shall be a civil debt owed to the victim of human rights violations. In addition, may takes into consideration the need to redress a public injury or the need to enforce a public duty. Now, with specific regard to the application before this court, the court takes judicial notice of the fact that several similar applications have been made and are pending before the Civil Division of the High Court. One such application is High Court's miscellaneous application number 0031 of 2025, retired Colonel Dr. Besigye and Haji Obed Lutale versus the Attorney General and Commissioner General of Prisons. An application for orders that are writ of habeas corpus and sub judice be issued, ordering or requiring respondents to produce the applicants before the High Court for appropriate orders. This application in the High Court has similar effects as the one before me. When two similar applications are made in both the Magistrates Court and the High Court under the Human Rights Enforcement Act, the following scenarios may occur. The first is jurisdiction. The High Court has broader jurisdiction and can handle more complex cases, including those involving non-derogable rights and freedoms guaranteed under Article 44 of the Constitution. The applications being similar before both courts, the High Court takes precedence. This also serves to avoid duplication of efforts and conflicting judgments. It ensures a more efficient legal process and consistent rulings. With that being the case, court strongly points out in coming to a decision the following. Dr. Besigye was granted bail in this particular matter on the 1st of July 2022 and has since been exercising his right to liberty. Secondly, the human rights violations raised were not committed within this court and or within its jurisdiction. An application whose decision has a similar effect as the one before this court, which is High Court MC number 0031 of 2025, retired Colonel Dr. Besigye and Haji Obed Lutale versus Attorney General and Commissioner of Prisons, is before the High Court and is being determined. The High Court takes precedence over the Chief Magistrates Court of Buganda Road. A decision by this court on prayers made has the effect of creating parallel proceedings and the potential for conflicting decisions and judgments, which curtails judicial efficiency. The application made by defense counsel in this court is hereby dismissed, the same having been improperly made before this court. The court, however, through its inherent powers conferred under Section 98 of the Judicature Act, stays proceedings in criminal case number 624 of 2022, and the rationale for this is here: to allow the human rights issues raised to be determined in the application before the High Court. Dr. Besigye, given his current health, is unstable and therefore unfit to stand trial at the moment. A stay of these proceedings is the most logical remedy to allow him to restore his health to normalcy. Proceedings are temporarily stayed for a period of 60 days. Since A1 is a public figure, criminal summons shall be issued when A1 is deemed fit to stand trial and a hearing date shall be fixed. In the interim, his bail is extended till such time.
Akajuli kale okayina ate kano akajuli ambasange bweru kazitene
Katamba.
It's a strange decision, but not surprising, because we know now the courts are operating under very difficult circumstances. We can understand what is happening with the judiciary and all the institutions of government, because now the orders of General Kaguta Museveni and the statements he has been issuing are reverberating everywhere. General Museveni and his son, all the statements they have been making, all the statements they have been making, as I've said, have got a chilling effect on all the processes in all the institutions of government. So we are not surprised, we are not shocked by this decision, which is quite ambiguous and a bit paradoxical. Paradoxical in a sense that the magistrate recognizes that she has jurisdiction to entertain the matter regarding Dr. Besigye's rights. But surprisingly, she goes ahead to say, no. You know, these are matters which can be handled by a higher court, the High Court. Secondly, that she has stayed the proceedings on account of the deteriorating health of Dr. Chiza Besigye. But she makes no orders as to the interventions that can be made to save Besigye's life, because that is really paradoxical. The moment court recognizes that Besigye is in a dire state of health, the only logical thing, I think it is axiomatic that what comes next is an order that please take him to a better facility where his health can be managed. Now the proceedings have been stayed for 6 months. The proceedings have been stayed, yes, for 60 days, for 2 months. For what? Then you order that Dr. Besigye be taken to a hospital with better facilities to properly manage his life so that he returns after 60 days to continue with the trial. She has said that Besigye is actually in a situation where he cannot stand the trial because of the poor health, that he can't stand the trial. What intervention have you made? What remedy have you offered? So 60 days to go to then to do what? Then again, paradoxical in the sense that she has extended the bail for Dr. Besigye, well knowing that he cannot enjoy the benefit of the bail. She knows that. And it is really disturbing to us that she distanced herself from interrogating the issues regarding his non-appearance today. Because there was an order. The last time we appeared here, the order was very clear. Prisons authorities are hereby commanded to produce Dr. Besigye today, the 20th of February, fair ruling. We come here this morning, all signs are very clear that Besigye is not going to be brought. And indeed, we enter court, some prison warder shows up, a question is put to her, please, where is Dr. Besigye around? No. And the magistrate does not inquire as to why Besigye is not brought here. He said, maybe I'll try to find out later and see why he is not here. That is really shocking. But finally, the fact that she would not draw the nexus between this matter and the violation of Dr. Besigye's rights. Because that's one aspect which really surprised us. That the violations we are talking about did not happen in this case and did not happen within our area of jurisdiction. That's rather shocking. At least on that one, she should have been bold enough to say, yes, this honorable court takes cognizance of the fact that Dr. Besigye cannot enjoy the benefit of the orders that were given by this honorable court to admit him to bail. Because he was granted bail. And his liberty is curtailed unjustifiably and unlawfully. So these are matters that warranted the intervention of the court to at least interrogate and investigate to find out why a person who was granted bail cannot enjoy those liberties. And she couldn't say anything about that. And you simply extend bail to somebody whom you know that he's before court, is incarcerated somewhere else, that bail is extended. Isn't this court bothered about making illusory orders? You have what we call nugatory orders, an order which has got no legal effect. Because now the question of bail, how is he going to enjoy it? So it has been rendered nugatory. But as I said on the outset, we know they are no longer in charge of all these processes. It's the same situation that happened before Justice Singiza yesterday. What has happened here is a trend. Now that actually even in Parliament, the caucus has been summoned to begin amending the law. So we know General Museveni and his family are in control of the process, and all these other agencies and institutions of government are just waiting for marching orders. They are just being frog marched and stampeded. So I think the courts are waiting for further orders. Parliament is also waiting for orders from General Museveni, just like any other agencies. That is the absurd situation we find ourselves in as a country. But we shall not tire from fighting for justice to prevail, for the rule of law, and for the Constitution to have significance. We are going to continue with this fight, and again we are going back to the drawing board to chart a new course, because we know once one door closes, of course we have to open another. Yesterday, High Court, they told us to write to them today to ask for a date when they will be giving us the ruling. We are going back to Justice Singiza and knock at his door and ask him, please, when are you delivering the ruling? You told us today you'll be telling us that the ruling will be delivered on such and such a day, and maybe he indicated that it will not be beyond the 25th. Okay, fine. Between now and 25th, what's going to happen to Dr. Besigye's life? Between now and 25th, how about the liberties he's supposed to enjoy and so on and so forth? So we are going to knock at the other doors. So, we are going to explore other options within the law. We are not going to give up. The fight is on. Thank you. Embeera ebaddewo mwenna mugirabye, etunyize naye tetwewunyisiza. Ekisooka kwe kuba nti Dr. Besigye tebamuleese, ate ne tusaba omulamuzi ne tumugamba nti munnange babuuze lwaki tali wano. Ng'era omulaba naye talaba nti kyangu nnyo okubabuuza, era atuuse n'okuwolereza omukyala azaawo, waliwo omukyala azaawo wa Prisons n'amugamba Dr. Besigye wandaga ataliiwo. Tatawanye mubuuza nti lwaki taliiwo. Agamba waayi sijja kgenda yeeyo mukazi wattu, era omulabye agaye mukazi wattu naye tamanyi. Ebyo by'okugandisiwa hapa birala. Bonna bali mu prisons, omugundi yeemu. Soyinza kujja wano ng'oleese ba suspects nga tomanyi kikwata kigenda mu maaso. So naye atuuse n'okuwolereza wa Prisons n'agamba nti mukazi wattu mumusaasire naye tamanyi. N'atugamba nti ajja gezaako okubuuliriza naye ebyo bibadde byakutugumyagumya kuba ate onoobuuliriza ate bigasa ki. So ne tusaba nti kale abeeko bwabakangavula kubanga bw'obwa ekiragiro kya kkooti nti Dr. Besigye mu mukomyewo wano nga 2 olwaleero awulire rulingi ye ne batamuleeta ne batawa nansonga kkooti eteekeddwa obbakangavula. Ennaku zino kkooti zifulumya contempt of court orders ne bwoba toliiyo nga gye bawadde Ssemakadde n'abalala n'abamakomera baali bataddeko ku contempt of court ne babagamba beesibe bo bennyini tebagituwadde court order. Tebakomye ku ekyo, omulamuzi n'agamba nti mpulira waliyo emmata eri mu high court eyo agambye awulira n'olw'ensonga eyo ye tajja kgenda mu maaso kubanga bayinza okubeerawo parallel decisions oba decisions ezikontana. Ni ffe bye twamusaba wano byanjawulo ku byasabiddwa eri yadde ekigendererwa kyakuta Dr. Besigye naye amateeka agabawawo obuyinza ganjawulo. Waliwo era ffe twaconcentratinga ku mateeka agawa obuyinza kooti eno. Tetwasaba habeas corpus wano. Wano tuli ku enforcement of rights. Era naye akikkiriza nti magistrate court eweebwa obuyinza okubanga omuntu yenna anyigiriziddwa eddembe lye ateekeddwa ayina eddembe okujja n'asaba. Akikkiriza nti obuyinza obwo kooti ebulina. Naye neyeekwasa ekyokugamba nti tuwulira waliyo ebikyali mu high court eyo katubirekere high court yeba ebiwuliriza. Kakati ekyo kya bulabe olw'ensonga nti gwe bw'oba olina obuyinza bwo kola ekikyo mu mateeka ky'olinako obuyinza. Ekirala ekitwewunyisizza maybe kwe kuba nti akkiriza n'agamba nti Dr. Besigye mulwadde era tasobola kujja wano mu kooti n'agenda maaso na musango n'aguyimiriza okumala ennaku 6. Naye bw'omala okukkiriza nti omuntu mulwadde muyi tasobola na kulinnya mu kaguli kugenda maaso na kuwulira musango gwe era kooti eguyimiriza, n'olw'ensonga eyo obaako ebiragiro byowa okutaasa obulamu bw'omuntu oyo. Talina kiragiro kyonna kyawadde kubanga yaligambye waakiri twaligambye nti tezifudda dda na lusoggo. Waakiri yaligambye nti n'olw'ensonga eyo ndagidde ng'omulamuzi mumutwale mu ddwaliro eririna obusobozi limujjanjabe, bw'anaamala okuwona n'abeera stable bulungi akomewaako wawere ennembe n'emisango. Naye agambye bugambi nti nguyimirizaamu okumala ennaku 6 nga bwe tulinda tulabe ndowooza simanyi oba nga kyekiriwaawo ko teyinza kutuula butuuzi. So ekyo nakyo kitunyize nnyo era kitwewunyisiza nti at least akatono teyalitidde mwami Yoweri Museveni ako yali kawadde kubanga ebirala byonna tukkiriza nti bibayinze. N'eki ekitono ennyo ekyoga nti ono mu mutwala afune obujjanjabi ekyo tekyali mulemye kuwa. N'ekisembayo kwe kuba nti agaye nti bail eri extended. Had bail eri extended ogyongeddeyo ng'ate okimanyi nti omuntu musibe. Kakati n'otanoonyereza lwaki omuntu gwe wawa bail tasobola kubanga ava wakaawe. Ekyo yali kibaddeko kyakiwaako ensala n'agamba nti bo nga omulamuzi nga bwe yawa bail alagira Dr. Besigye yenjoyinga ebbeeru ye gye yamuwa kuba akimanyi ate kati musibe ate akimanyi tewali misango mirala yennyini mumuwulidde talina musango gwagambye nti bamuvunaana guno. Kakati naye mu kubigattagatta byonna ne kooti tugisaasira ne mukyala Siena Bambi naye tumusaasira. Mukyala Nancha naye tumusaasira era tumusabira. Tumanye entebe gyatuddemu awo eyokya. Eggwanga kati liri mikono gya General Yoweri Kaguta Museveni ne mutabani we maybe ne muganda we be balagira kati balagidde high court mwalabye ebyabaddeyo jjo balagidde parliament caucus mbwetule mangu bakubirire baleete ekiteeka ekikomyawo general court martial era essaawa yonna ndowooza parliament yafunye gye bayita frog marching. Kakati nabano bambi bali mu bitengo fayiro buli lwe bagikwatako buli akwata ku fayiro ya Besigye efuuka hot potato eyokya buli agikwatako agamba nfudde buli mulamuzi akwata kati ku fayiro ya Dr. Besigye agamba munzise Singiza agamba munjagaza ki Mukyala Nanki agamba bannange mumbeeredde ki n'abalamuzi abalala buliro bawulira nga tujja kati n'abawulira ne tugambye nti tujja wa Singiza agamba bannange munona ki kuba tumugambye tugenda kati musaba lulingi manyi bw'anaabiwulira bino nga mubifulumiza mawulire nga bannange munona ki tumanyi embeera gye balimu katubasabire nga naffe bwe twesabira naffe tetugenda kuwummula buli lugi lwonna olutuweebwa mu mateeka tugenda dukonkonako era tubategeeza kawabe wa principal judge kawabe wa chief justice kawabe luddawa buli lugi lwonna amateeka geratuwa okulaba nga tufuna obwenkanya n'okutaasa obulamu bwa Dr. Besigye tujja dukonkona munaagaana buganyi okutuwuliriza oba okutuggulira naye tugenda dukonkona na wano tugenda kudda Mukyala Nanki tukomawo n'abalala tugenda kujja olutalo olufe lukyagenda maaso okutuusa nga Dr. Besigye avudde mu kkomera ate ng'afunye obwenkanya mwebale nnyo mwebalire ddala.
Well, there are two things. One, what is happening is putting the judiciary and parliament on trial. You see judiciary and parliament on trial. And it is in the best interest of these two institutions to save themselves of what the executive is targeting out of them. That for them to survive as independent institutions, they must stay away from the target of the executive. Two, that you don't see the urgency within the judiciary to save Dr. Besigye from dying in prison. And that's why what is happening in this court is similar to what happened in the court of yesterday. That you say this man is too sick, take him to prison. He's too sick to be here, take him to prison. This is what the magistrate has said, and that's what the judge yesterday said. That no, Dr. Besigye cannot stay in my court. Please take him to prison. And then do what? It defeats the purpose for which Parliament had to request the Attorney General and Minister for Constitutional Affairs to go and bring forward the date of hearing Dr. Besigye's application from 25th to yesterday. Because we said as Parliament that we cannot wait for 25th. Bring the day closer. Now you bring it closer, but even then the judge is saying, no, I'll give a ruling around the 25th. But then why did you bring the day closer? So it defeats the purpose. Now, on even this one, he says, no, okay, go and come back after 60 days. 60 days of being where? So, which now means that as Parliament, we must be now the court of, the result now must be in Parliament. I saw yesterday the Parliament of Kenya discussing the rights of Dr. Besigye, discussing the health of Dr. Besigye, the life of Dr. Besigye in Kenya. Kenya cannot be discussing Dr. Besigye and how Dr. Besigye should get out of prison, and for us we don't. And so now I think it's incumbent on us as members of Parliament. Fortunately we had started on it. Fortunately the Speaker had started on it. We must go back to Parliament and fight for the rights and health of Dr. Besigye until he gets out, because I see circus in the judiciary. I see circus in court. I don't see the urgency in the courts of law. Ekigenda mu maaso kitulaga nti judiciary ne Parliament ziri ku trial. Kubanga executive eyagala Parliament ne executive zikora ebintu nga executive bweyagala. Kati ezo institutions zombi bwe ziba zaagala zibeere zikyalimu omulamwa, zikyali independent, zirina kuvaayo zeerwaneko, zirage eggwanga nti zikyaliwo. Tosobola kugamba nti ono mulwadde tasobola kubeera wano mu trial mu mutwalo eruzira. N'okyogera mu magistrates court nti ono mulwadde nnyo alinde ennaku 6 okukomawo wano, naye mu mutwalo eruzira. n'okyogera ne mu high court nti Besigye tasobola n'okubeera wano eddakiika 3 mumutwale mukomera mulwadde nnyo mumutwale mukomera ng'okola ebyo executive byeyagala oba ku trial ng'ensi yonna ekulaba judiciary badde evuddeyo mu bya Supreme Court n'esala bulungi naye kati bano abawansi tebamenyawo respect ebadde evudde mu Supreme Court. N'olwekyo John alabye paramenti y'e Kenya ng'eyogera ku nsonga za Besigye ku bulamu bwa Dr. Besigye n'eddembe lya Dr. Besigye ng'e Kenya babyogerako. Naffe wano tubadde tubitandise naye kati ekigenda mu maaso kimazemu amaanyi kyekye twarwanira nga paramenti nti tuve ku lunaku lwa 25 tuteeke ku jjo application ya Dr. Besigye. N'olwekyo kati katuddeyo mu paramenti ng'ababaka judiciary bweba teri mu bwangu kukikolako ffe tubeere nekitukola Dr. Besigye ave mukomera paramenti ekisobola obuyinza tubuyina katuddeyo mu paramenti tutandikiraawo we twalekera ku Olwokubiri.
All for freedom. All for freedom. Freedom for all.